Today on E-Commerce Heroes, I'll be talking to CJ Rosenbaum about intellectual property rights for Amazon sellers. We'll be covering what Amazon sellers need to know about intellectual property, what to do if your intellectual property rights are violated by a listing hijacker, and how to protect yourself from potential intellectual property issues when sourcing products from China. In today's episode of E-Commerce Heroes, I'll be talking to CJ Rosenbaum about intellectual property rights for Amazon sellers. CJ is an attorney and the founding partner of AmazonSellersLawyer.com. So CJ, what are the main areas of intellectual property that are relevant for Amazon sellers?
All right, when it comes to Amazon sellers, the three relevant parts are trademark, copyright, and trade dress. Patent law does play some role depending on what you're selling. But usually the patent issues are fairly minor. It only has to do with design patents, not so much utility patents or patents in the UK. But those are really the three categories that are four major categories that have to do with sellers: trademark, copyright, patents, and trade dress.
Okay, so what do Amazon sellers need to know about these three areas?
Okay, when it comes to trademark, the best way to answer that is to give the listeners just a real Billy basic, trademark 101. Trademark is a mark or a logo that indicates the quality of the product. Apple logo, McDonald's, the web retailer logo behind you. Okay, that's a mark or a trademark. The way those come up is with sellers when they're selling genuine products in the US, there's no violation of the trademark. If you're accused of violating a trademark, you're selling a genuine product, the complaint is nonsense. On the other hand, if you're selling in the UK, permission to sell plays a significant role. But if you're selling on .com, as long as it's genuine, the trademark complaints are generally baseless when it comes to sellers.
Okay, and how about things like copyright? How does that apply to a seller's listings and the images they use and things like that?
Copyright law pertains when it comes to sellers almost exclusively to the images, to the pictures, and to the verbiage used in the listings. For example, you can't use someone else's picture off their box or from their commercial or scrape from their website and use it to create your own listing. That's clearly a violation. And you also can't cut and paste somebody else's verbiage and use that. If you're not doing one of those two things, chances are you're also, at least in the US, not violating anybody's rights, even though you may draw accusations.
And I think some of our viewers will be familiar with copyright, trademarks, and patents. But trade dress is perhaps one that isn't quite so well known. So could you just give us a little bit of background on that as well?
Yeah, trade dress is really like a touchy-feely concept. It's the entire packaging, it's the entire look, feel, colors that a package comes along with. There's a great example in a sponge called the Beauty Blender. And it's like this egg-shaped sponge that women use to put on their makeup. It's like a fuchsia color. It's got a very specific texture. It's packaged in this clear packaging. And it's a very popular product because it has such great trade dress. So that whole concept of the whole look and feel of it, that's trade dress. Another product is there's a humidifier that's in the shape of a teardrop. And that teardrop shape and the way it's packaged and the way it looks, that's good trade dress. It's a really unique look, feel, packaging, texture, and color. And all those things together, that's trade dress.
So with these factors in mind, there are some common scenarios that we hear about from sellers where intellectual property plays a big role. I think the primary one is where sellers who have their own private label or a brand and so own their Amazon listing find that someone else comes along and starts selling on it. So is this a violation of their intellectual property rights? And if it is, what can they do about it?
Okay, often it is and often it's not, okay? A lot of the time, especially for private label sellers, as your product gains traction, as you gain a reputation, you are going to have hijackers. And sometimes they will violate your intellectual property rights. They'll use your images, they'll use your verbiage. And then those are really easy ones to knock off the hijackers. Other times when you have holes in your distribution chain or your factory, which I know we're going to talk about later, is selling your products to somebody else, there are other things that we need to do to get those hijackers off. And brand protection for private label sellers who are riding this wave of developing their own product line is a significant portion of what we do in our law firm, that we can build in IP rights. We also know how to build in certain things to get hijackers off that really may or may not are not really necessarily intellectual property, but we focus on helping sellers with their private labels and getting those hijackers off.
And so what are some of the ways that if it is an IP violation, that you can enforce your IP rights and get the other seller off of that listing?
Okay, if they're using your images, if they're using your verbiage, if they are not delivering the same product, warranty, and there are some other issues, it's pretty easy. What we recommend everybody does is if you need to get rid of a hijacker, that you first try and do it amicably, and you send what we call a cease and desist letter or a cease and desist email to those sellers saying, you're violating our IP rights. We'd like you to get off the listing without taking any steps that are going to harm you or your account. And that will get rid of like 70, 85% of the hijackers. They just don't want to bother or take the risk of getting in trouble. Other sellers may write back to you and say, listen, we have 20 units left. We have 50 units left. Can we work out an agreement so we sell out our inventory and don't take a bath, and then we'll get off your listing. But the ones where there's a significant IP violation, it's very easy to get them off by using cease and desist letters. And then if that doesn't work, then making a complaint through Amazon's their form system online.
And you mentioned cease and desist letters there. Do they always have to be written by a lawyer, or can sellers do them themselves?
No, sellers can do it. You can do it yourself, especially if you have brand registry 2.0. It's really much easier for the seller to do themselves. It's faster. It's more efficient. We can guide you in what to put into the email. But reality, what you're saying is basically, dear seller, you're violating our IP rights, and identify you using our image, using our verbiage. We'd like you to come off the listing voluntarily so that we don't have to make a complaint. And it doesn't have to be that verbatim. That's really all you need to do. And a lot of the hijackers will get off, or at least reach out to you and work out an amicable termination of their sales on your listing.
Okay, so you mentioned factories earlier on. And another scenario that we see quite often is where a seller will go over to China. They'll purchase thousands of units of an item, only to find when they get home that the product they've brought violates someone else's design or their trademark. And then they kind of have this whole shipment that's useless because they're not allowed to sell it. So what can sellers do to avoid getting into that situation?
Well, we deal with this problem, I'd say at least once a week, if not more. If you're going out and you're sourcing, whether it's in China, Thailand, Vietnam, wherever you're sourcing, India, you need to do your own research. You can't rely upon the factory owner or their middleman to tell you whether there are or not property rights. Most factories are not in the business of designing products. So chances are that they didn't design the product themselves. It was somebody else who submitted the design to them, and then they ran with it, or they tooled up their factory for another company. So what you can do is start doing the research yourself. And right out of 1996, there's this great website called USPTO.gov, United States Patent and Trademark Office. And it's pretty easy to navigate, and you can do your own research before you commit too much money to a product that a factory owner is telling you that there's no issues. Or we can do it for you. We charge less than $1,000 US to research a product and give you an opinion letter. But I'm a big believer in teaching sellers how to help themselves. You can do the research yourself. Also, you just use Google, go on Amazon, and see what's going on with similar products, and read the forums and see if other people are selling it, and more importantly, if they're having any problems.
And is there anything that sellers can put into their contract with that supplier, such as restrictions, to kind of avoid that happening? Or do you think that research alone is the best way to kind of protect yourself in that scenario?
The best is the research. Contracts are only good if you need to go to court or to enforce them. In China specifically, they give you a little added weight because most Chinese business people want to have absolutely nothing to do with the government. So even the threat of taking them to court is very effective. But I think the main goal of business people is to avoid needing to address a dispute. You want to do a dispute avoidance. So do your own research first. And then if you're comfortable with it, or you get a good opinion letter that you think it's something you should go forward with, then of course a contract would be useful. But enforcing it's really not a good way of going. Litigation generally is not great for sellers, except in really limited circumstances.
Okay. And what if the scenario happens the other way round? So a seller goes to China, they get a factory to produce a new product for them, and then further down the line, that factory copies it and sells it to another person. What can a seller do to protect themselves in that case?
Okay, we also get calls about this every week. Okay, for private label sellers, your number one threat, by far, your number one threat is your own factory. Okay, your own factory is going to produce, 10,000 units for you, and then another 10,000 units that they're going to sell to other sellers, and then they're really not counterfeit because they're made by the same people in the same factory with the same raw materials. So they're not counterfeit; they're gray market. So what you need to do if you're sourcing, and I don't want to bash the Chinese because there are a tremendous number of really honorable, great, successful business people there. But when you have, 90% of all the factories located in one country, you also have 90% of the counterfeits and the gray market issues. So what can you do? I think first, you need to make sure that your factory knows you. You need to develop a relationship with them. You have to get on that plane and go there. It develops what's very important in the Chinese culture called guanxi, which is a relationship and about losing face. If they know you, they're much less likely to pull one over on you. Okay, so you need to do that. And if you can't do it yourself, you need to hire someone who can stop by the factory and have the cup of tea with the factory owner. And they sit down, there's a whole tea set where there's a whole thing where they clean the cup and a certain way of making the tea. And you need to do that. You need to either you do it yourself or have someone else do it. You also want to have it in documents that they're not going to do an extra run and give it to other sellers. But the best way of preventing it is to develop a relationship with your factory. Number one way of preventing the problem.
So my final question for you, CJ, is what are your e-commerce heroes' top 3 tips about intellectual property for Amazon sellers?
Okay, my tips are for private label sellers, developing your own brand. And I guess these are also applicable if you have a distribution, you're selling other products. But number one, if you're developing something, get your trademark. File your trademark. In the US, it's really easy. Sellers can absolutely do it themselves. You don't need to hire a lawyer. You file a form, and since the US is the largest market, that's why I recommend you do it. It doesn't matter where you're a citizen. File with the uspto.gov, fill out the form yourself, and submit it. It's roughly $225 to $275 per category, and do it yourself. If you have a problem, then call us and we'll try and walk you through it. But first, get the trademark protection where you're going to sell, your largest market. Then for like another $300 US, you can file for protection around the world through WIPO, the World Intellectual Property Organization, WIPO. You can file through WIPO in China or in Thailand or Vietnam where you're sourcing. It doesn't give you the best protection, but it gives you something to hang your hat on. And then it gives you something to show to the factory owner if they do an extra run, saying you're violating our rights. We don't want to get the government involved. Please stop. So that's number one, file your trademark. The number two is that when you enforce your rights, to do it amicably. Do the cease and desist letter. And why? One, I think it's the right thing to do. I think that you don't want to needlessly put people out of work or needlessly cost them their business. But I think also from a business perspective, we all live and die, okay? We live and breathe by reviews. We live and die by A to Z complaints. And the last thing you want to do is to create animosity when every single employer, relative, friend, and neighbor could start leaving you bad reviews or buy your products and make A to Z complaints. And all of a sudden your ranking just goes down like a stone. So by resolving things amicably, it's cheap, it's fast, it's efficient, and you avoid creating animosity. Number three, I think, is that all sellers need to take a long-term view of their businesses, okay? There are certainly ways of getting rich quick or making a lot of money very quickly. Amazon's lawyers use it. They call it the hit and run fraud guys, okay? And you can make a few bucks by never delivering products or delivering garbage, and then you'll be shut down. You do it again. There's ways of making money doing that, but that's really dodgy. What you want to do is take a long-term view of your Amazon account and really do things methodically and carefully. And I think those are probably the top 3 tips for intellectual property, for sellers, for private label people, to watch protect your rights and also make sure you're not violating others, to enforce your issues amicably, and also just take a long-term view of this business. There is I think the greatest opportunity in the history of commerce where everybody, if you have a phone and a credit card, you can now compete worldwide. So long-term view, and that would be my top 3 tips for Amazon sellers.
Well, CJ, thank you very much for your advice. I'm afraid that's all we've got time for today. I'd also like to thank everyone at home for watching, and we'll see you again soon for another episode of E-Commerce Heroes here at Web Retailer. Goodbye.